Assalamualaikum and a very good day I bid to Madam. My name is ZARITH SOFEA binti ISMAIL SHAH and my metric number is 273247. We are from Group 7 and we would like to present regarding the law relating to illegal gathering in Malaysia. First of all, I will be explaining regarding the legal meaning of criminal offences along with the offence provision, and the rest will be explained by my group mates. In a legal perspective, an illegal gathering is referred to as unlawful assembly of a certain number of people with the same objective, which is to engaging in unlawful activities that jeopardize the security and public order. According to Section 141 of Penal Code, it is defined as an offence when there is assembly of 5 or more persons with a common object, which is to exert criminal force on any public servant that exercise lawful power, to resist the legal execution, to commit any criminal trespass, to obtain possession of any other person's property, and also to force someone to do an illegal act.
Hi and Assalamualaikum. I'm MAWADDAH binti SAYUTI and my metric number is 273278. So today I'm going to discuss on the first and the second elements of unlawful assembly. So the first one is the participation of 5 or more people, where it is not necessary for any of the individuals to be apprehended or convicted of a crime, but proof must exist that 5 or more people, whether known identity or not, were present at the assembly and participated in its common object, where the identity of the member to an illegal assembly could be determined by the convicted member's guilt to be used as an evidence. So, Section 147 of the Penal Code also can be used to convict fewer than 5 people in an illegal assembly. So we can see in the case of Amar Singh and against State of Punjab, where 7 people were initially charged with being members to an unlawful assembly under Section 148 and 149 of the Indian Penal Code. But the court ruled that the convictions of the remaining 4 could not be upheld under Section 148 and 149 because this section requires a minimum of 5 people to be applied. As a result, the 4 accused persons cannot be charged because the court acquitted the other 3 accused persons. Secondly, under Section 141A of the Penal Code, it states that if the common object of the individuals composing that assembly is to overthrow by criminal force or display criminal force the legislative or the executive of Government of Malaysia or any state or any public servant in the exercise of the lawful power of such public servant, that assembly is classified as unlawful assembly. So the common object that constitutes unlawful assembly under this provision refers to an intent to overthrow by criminal force or by show of criminal force. For the court to convict a person under this offence, the common object of the member of that unlawful assembly must be overthrown to a public servant, as it is insufficient to convict them under this clause if there is a mere fact that they did something overall towards the public servant. We can see in the case of Fung Yin Ching against PP, where the appellants were charged with being the members of an illegal assembly whose common object was to intimidate the state government in violation of Section 143 of the Penal Code. The Chief Justice found the appellants guilty of unlawful assembly and rioting under Section 143 and 147 of the Penal Code.
My name is ADRIANA MAZNI. My metric number is 273235 and I'll be continue presenting about the elements of the unlawful assembly. So next, in section 141 subsection 1b, an unlawful assembly is described as a group of 5 or more people whose common object is to resist the execution of any law or legal process. So legal process here refers to a process or procedure in accordance with the law, and the convicted person must have the intention to resist it in order for the court to convict him under this provision. So in the case of Siva Segara Kana Patipilai against public prosecutor, the appellant was a member of a group of lawyers who assembled at Parliament's Gate, and they handed out pamphlets about the proposed amendments to the Societies Act to the people driving to the gates. The appellants, along with other attorneys, was charged with participating in an unlawful assembly in the public space for which no license had been issued for them. However, the court held that knowledge and intention are the necessary elements that must be proven before a person can be convicted. The 5 lawyers who were arrested had no such intention, and consequently the defendants were not found guilty of unlawful assembly. So next, in section 141 subsection 1c, an unlawful assembly is described as a group of 5 or more people whose common object is to commit mischief, criminal trespass, or any other offences. So for the definition of mischief and criminal trespass, it was defined in section 425 of the Penal Code, where any person causes the destruction or other change of any property or institution thereof with the intent to cause, or knowing that he is likely to cause, unlawful loss or harm to the public or any individual, is said to commit mischief. So in section 441, on the other hand, of the Penal Code, whoever enters or remains on another's property with the intent to commit an offence, or to intimidate, insult, or to annoy any person in possession of such property, or lawfully entered but unlawfully remains in that property with the intent to intimidate, insult, or annoy such person with the intent to commit such offence, is said to commit criminal trespass. However, for the term of any other offences has been given broader meanings, in which may include things punishable under Penal Code or any other written law. So in the case of in Ong Chin Seng against R, the appellants were found guilty of being members of an unlawful assembly in order to cause hurt with a dangerous weapon as a common object, as well as the murder of Ong Hok Soon, which all of the members involved aware that was likely to be committed in furtherance of the assembly's common object. So sections 149 and 302 of the Penal Code were used to convict them, and the court decided that the common intent to injure others with the dangerous weapon was caught by the words or other offences, and therefore came under section 141 subsection 1c.
Good day, I'm Genevieve Ling with metric number 273158. The element of unlawful assembly can be seen in the section 141 subsection 1d, that unlawful assembly is defined as a group of 5 or more people whose objective is to attack or obtain possession of any property, to derive any persons for the enjoyment of a right way, the use of water, any other intangible right, or which is in possession, right by using to show the criminal force. This can be seen in the case of Babin Bahari Guha versus Pranako Majuda, that there were 2 parties in this case who shared joint ownership of a house before one of the parties was no longer in possession. The servant of the party, along with 30 or 40 men, armed with guns, possibly took the possessions of property, but then were able to take control of property without using any force. The court held that the servants' actions constitute unlawful assembly, as there were more than 5 servants who expressed their criminal force by being armed with weapons, and they all have same common object in mind, that is to possess possessions of victims' property. Next, we can see in section 141, subsection 1e, that unlawful assembly is described as a group of 5 or more people whose common object is to use criminal force or threat of criminal force to compel another person to do anything he's not legally bound to do, or to omit something he's legally entitled to do. So we can see in the case of Abdul Sattar P that a possession was held along a public highway along with music. However, a group of Muslims attempt to stop the possessions due to their intense opposition to any possessions of music passing in front of the mosque. The Muslims threw the brickbats, stones, and soda water at the possessionists in attempt to disperse and block the possessions from moving forward. The court held that the possessionists were not in a role for conducting a possessions, regardless of whether or not there was music, since they have the right to do so on a public highway. Furthermore, it is clear that the common object of Muslim assembly was to prevent the possessionists from entering the possessions, as well as to induce possessionists to omit doing what they were legally entitled to do, either by force or the display of criminal force.
Hi, Assalamualaikum warahmatullahi ta'ala wabarakatuh. A very good day. My name is Siti ATHIRAZATTI BINTI ROHIZAD with metric number 273244, and today I will be explaining on the elaborations regarding our topic, which is illegal gathering or unlawful assembly, and also what are the main punishment of this offense as stipulated under Penal Code. So first and foremost, even though citizens of Malaysia, they have the rights of freedom of assembly, which allows them to express their opinions without resorting to violence under Article 10, Clause 1B of the Federal Constitution, where this particular provision guarantees the right to peaceful assembly. However, there are several conditions that need to be fulfilled under the Peaceful Assembly Act 2012 as a replacement for Section 27 of the Police Act 1967, or else it would have been an unlawful assembly. And also, it must be noted that a said freedom is a natural privilege rather than a question of right. So one of the prohibitions under unlawful assembly is the possessing weapons or missiles under Section 144 of Penal Code. So you can see in the case of Priyasami and another against PP, where the appellant, he took part in a riot and used a weapon which resulted in a murder. So he was then charged with possessing a weapon in unlawful assembly that is likely to cause death in a riot under Section 144 of the Penal Code. So this provision states that any person who attends, participates, and he is caught in a lawful assembly with a firearm, ammunition, corrosive, injurious substance, stick, stone, or any weapon or missile that is capable of being used as a weapon of offense, he shall be punished with imprisonment for a period of 2 years and fine or both. So moving on to the main punishment for criminal offense. So Section 142 must be read together with Section 143. So Section 142 said that anybody who is accused of knowing or intentionally participating in an unlawful assembly, so he is considered as a member of that particular unlawful assembly. So he can be charged under Section 143, which explains whoever is a member of an unlawful assembly, so he shall be punishable with imprisonment of a jail term up to 6 months or fine or both. So in this context, when a person commits an offense under Section 142, he can be charged accordingly with Section 143, which is to be sent to prison for 6 months or fine or both at the same time. So I think that's all from me. Thank you.